So I think we can start. And I would, of course, first like to introduce myself. My name is Dr. Tlaleng Mufokeng, and I'm the United Nations Special Rapporteur on the right of everyone to the highest attainable standard of physical and mental health. And on this particular day, I would like to thank the Center for Global Health Policy and Politics, the Center for Health and Human Rights, and our equity for bringing us, all of us together to continue this critical South to South dialogue on sexual and reproductive health justice. I dedicated my tenure as the UN Special Rapporteur to the ideal of restoration of dignity, understanding that as a practicing medical doctor with a focus on sexual and reproductive health, that the practice of medicine in itself is a way of defending and promoting human rights, especially for those who are affected by structural inequalities and those who are experiencing intersecting but also multiple forms of discrimination, either due to their age or disability, gender expression, gender identity, sexual orientation, occupation such as sex work or socioeconomic status. And all of these we know leads to discrimination, criminalization, and often social exclusion. And some of these obstacles we know have their roots in patriarchy and colonialism. Others, of course, are related in terms of structural and systemic inequalities. But ultimately, when it comes to the right to health, why all of this matters, why this conversation today is important, is that all of this leads to differential access to the enjoyment of the underlying social determinants of health, but also to the right to health. And in all the different ways and interventions that I have participated in, and through the various reports, I have asserted how patriarchal oppression itself is universal. It permeates all societies, and its very origin is the erosion of autonomy, and it seeks to control the girls' and women's bodies and our own sexualities to the detriment of our own enjoyment of our sexual and reproductive health rights. And we know the different restrictions on abortions as well, in terms of same-sex marriage, any kind of autonomous being or state is often a contested space. And so we know that for example, expression of gender diverse people in recent times has become another place of contestation, another place where patriarchal control expresses itself. But discrimination in law and in practice and in policies directly impacts people's ability to enjoy their human rights. And when it comes to the right to health, when it comes to accessing healthcare services, we know that discrimination is pervasive. It's a pervasive issue globally. And women, girls, and gender diverse persons face numerous barriers when seeking healthcare, including denial of care or unequal treatment or access barriers to reproductive health services. And
El
some of these
cuidado o
practices
el que sea un
do not
cuidado
only violate
desigual.
women or
Esas prácticas no solo
LGBTQIA+ people's
violan
rights, but
los
they
derechos
actually
de las
directly
mujeres o de las
contribute
personas
to
de la
health
comunidad
outcomes
LGBTQ,
and
pero también
accessibility of
contribuye
existing health inequalities. Now, to draw us back to the conversation around the use of the law and why the law is so powerful as a tool to protect human rights, and why, for example, as
a
a
la
medical
hora
doctor,
de
I always
protegerlos.
explain my role at the UN as the medicine and the law colliding. And when the collision happens, we can have really good outcomes when we are intentional about how we use the law. And all member states of the United Nations, of course, have legal obligations that they must live up to. And under, of course, human rights standards, they must decriminalize abortion, repeal laws that prohibit access to emergency contraception, ensure respect for
Para
and protection
asegurarnos
of fulfillment of
de
sexual and
respetar
reproductive health rights for all
y
people,
poder
even during times of emergencies. And I think it's important to talk about moments of emergencies, humanitarian crisis, protracted war and conflict, even genocide, because we know even in those moments, it is often sexual and reproductive health rights that are often the first to be violated. And so, as we talk today, we need to recognize, of course, that reproductive justice, therefore, as a concept, is very important in how the law can be used and must be used for social justice, for reproductive justice. And therefore, today, I call on all of us to appreciate the ways in which all of the different systems intersect, the different systems of power intersect, and how this conversation can leave all of us
se
feeling a little bit
atraviesan
more armed, I suppose, and more empowered and enabled to be able to take on what often feels like insurmountable, challenges in the world. And today we are joined by incredible, distinguished speakers,
unen a
which are critical
nosotros
to this time,
unos
this moment,
oradores
the
increíbles,
lessons that we need to
distinguidos,
learn, especially as
críticas
we
en este
go
momento.
through the South to South dialogue on advancing sexual and reproductive health rights. And I'm honored to introduce to you all Honorable Adriana Ortega, who's a magistrate in the Federal Court of Appeal in Labor Law in Mexico. Welcome to Honorable Justice Omondi Helen Amolo Owini, who's a
Bienvenida
judge of appeal
a
and
la
president of the
honorable jueza
Association of Women of Judges in Kenya. And of course, Prudence Mutiso, who's a senior legal advisor for Africa for the Center for Reproductive Rights. And of course, Estefany Martinez, who's managing attorney for the Latin America and Caribbean region in Women's Link Worldwide. And so, good evening, good morning, good afternoon to all of you, because I know you are joining me from all over the time zone in the South to South dialogue. And thank you very much for joining us. And I have a question immediately, of
Muchas
course,
gracias por
for
unirse a
Honorable
nosotros.
Adriana. And of course, Justice Omondi isn't here yet. Hopefully, they will join us. But I think, Honorable Adriana, you are still well able to represent us as our justice today. More broadly, what do you see as the role of the judiciary or the courts in protecting sexual and reproductive health rights, especially in this time where the anti-gender
Especialmente en
movement
este
is so
momento,
loud and bold in how that they pronounce, their anti-human rights stance. So the role of the courts and judiciary, in your opinion, how do we move forward, Honorable Adriana?
Thank you first of all, thank you very much for the invitation. Very nice meeting you all. I am honored as well to be here. I will say it, but when it comes to Mexico,
tengo que
seems
decir que
very
cuando tiene que ver con
difficult to
México,
foresee to some extent
es
the
bastante
behavior of the
difícil
judiciary and the Mexican
determinar de
Supreme Court.
antemano.
In other circumstances, I don't know, maybe 1 year or 2 years ago, my immediate response to your questions would have been that the Mexican Constitutional Court should be expected and can be expected to play an outstanding role in the protection of sexual and reproductive
Un
rights
papel
and to enhance and defend
destacado a la hora
jurisprudence
de
regarding gender equality and gender justice. In this moment, it seems problematic to make this assumption. For a long time now, I used to be a human rights lawyer. I was a clerk to the Supreme Court, and finally I became a judge. I have been completely convinced that litigation before the courts has proven effective for the enjoyment of sexual and reproductive rights in the region, not only in Mexico, but in the region and in general, at large.
dar por
In this
completo
moment,
los
I
derechos
think that at least in Mexico, the time has come to undertake a different legal strategy. I will come back to this point in the following participation. As you may know, I would like to take the opportunity to make you aware of this. Mexico is facing a judicial reform intended to change the whole integration of the judiciary to achieve control over judicial decisions with the creation of a judiciary discipline tribunal. This tribunal is the
un
body
tribunal
with the
disciplinario
authority to punish judges either with disciplinary measures or even with the ability of the opportunity to report them to the general attorney. And finally, the reform proposed and achieved, the reform is already in place. And finally, to elect justices and judges by popular vote. Another worth noting reforms that affects directly amparo proceedings. Amparo is the Mexican equivalent to tutela in Colombia or to amparo in Argentina. In the past, amparo proceedings had been often used in Mexico to force government officials and the legislative power to comply with constitutional and human rights, whether they like it or not. The reform that has been adopted recently regarding amparo proceedings deems that amparo cases that challenge laws on constitutional grounds can never have overruling effects beyond the specific case. Even though amparo decisions have always been restricted in Mexico, this reform intends to stop the undeniable advances to overcome such limitation. In the last 4 years, organizations with legal interest in promoting, protecting, and fostering sexual and reproductive rights had achieved decisions with general overruling effects. Most of these Mexican NGOs resort mainly to amparo
Estos ONGs
litigation to
mexicanos
foster changes in legal framework regarding, for example, abortion. I think litigation regarding abortion has been very strong in Mexico, and access also to reproductive health. When it comes to the soon to be former, because it's going to disappear, Mexican Supreme Court, these constitutional challenges had always been successful. That means that the court has always decided in favor of sexual and reproductive rights. There is not a single Supreme Court decision. On the contrary, you
del
can
Tribunal
state
Supremo
de manera contundente, I'm sorry because I will switch to Spanish for a while, de manera contundente that the Mexican Supreme Court has always fostered, has always respected, has always protected human rights of women and persons who can get pregnant. In this point, okay, thank you. In this point, it is hard to anticipate what will happen in the Mexican courts. Never mind, Mexico is
los
governed by
mexicanos,
a woman president and by a
sin importar
left-wing
que
party. In my opinion, one still can identify very worrisome authoritarian traits in the present government. So everything is yet to be seen, At least in my particular opinion, there are reasons to be worried and concerned. And this will be my first answer to your questions, Dr. T. Thank you very much for it.
Thank you very much, Justice Ortiz, because you know the example that Mexico does set in terms of litigation, especially around abortion, is really, really important. And I know that many courts use each other's, findings and jurisprudence in many ways. And I know even as a young activist, some of my early learnings and teachings, used to come from the courts in Mexico. So thank you very much for those insights. And I'll definitely be coming back to you, with more questions. I want to bring in Estefani now and Prudence, and I'm going to ask you both the same question. And maybe Estefani, you can go first and answer what have been the most persistent legal or constitutional barriers to advancing SRHR in your area specifically. We know about safe abortion, adolescent, and young people and their autonomy, LGBTQ plus persons as well, the issues around sex workers and their human rights. So you may, of course, give us, some of the examples of how you've navigated these challenges as well in court. So over to you, Estefani. And if you need, of course, translation and interpreters for our participants, please click on the icon that is the globe for interpretation so you can hear Estefani. Thank you so much. Over to you.
Thank you very much, Dr. T. I will switch into Spanish. Primero, una disculpa por la voz, estoy un poco enferma, pero muy contenta de estar en este espacio pues tan importante de reflexión. Y me gustaría primero dar las gracias a la honorable relatora especial de las Naciones Unidas sobre el Derecho a la Salud y al Instituto NIL por abrir este espacio tan importante de reflexión. Voy a hablar desde el trabajo que Women's Link Worldwide está haciendo, organización a la que represento, pues es una organización feminista que litiga desde una mirada interseccional, antirracista, anticapacitista y decolonial en América Latina y el Caribe y en otras regiones del mundo, pero específicamente me voy a centrar en la región de Latinoamérica y el Caribe. Muchas de las barreras para contestar a su pregunta legales y constitucionales que enfrentamos para avanzar en los derechos sexuales y reproductivos no son neutras ni accidentales. Están profundamente arraigadas en estructuras coloniales, patriarcales y racistas que afectan definitivamente de forma desproporcionada a mujeres negras, afrodescendientes, indígenas, adolescentes, niñas, mujeres rurales, personas con identidad de género diversa y también trabajadoras sexuales. Una de las barreras que hemos identificado que son más persistentes es la colonialidad del derecho, que por supuesto criminaliza el aborto en todas las circunstancias, niega el acceso a educación sexual integral y normaliza la tutela sobre los cuerpos. Lo hemos visto en contextos como en República Dominicana, en El Salvador o Ecuador, donde acompañamos a mujeres directamente afectadas por estos marcos legales opresivos. Además, también presenciamos una instrumentalización regresiva de los principios jurídicos por parte de sectores conservadores que incluyen, pues, por supuesto, varios jueces y juezas de las altas cortes, ¿no? Por ejemplo, en El Salvador y República Dominicana se ha desvirtuado el principio de la vida desde la concepción, utilizándolo para criminalizar a mujeres por emergencias obstétricas, por ejemplo. También en Ecuador y en República Dominicana se ha desvirtuado el interés superior del niño o de las niñeces y se ha usado para obligar a niñas a continuar embarazos cuando son producto de violencia sexual. En Chile también tenemos otro ejemplo de la objeción de conciencia institucional generalizada que opera como una barrera estructural para el acceso al aborto, ¿no? Todo esto ocurre, por supuesto, en un contexto también de racismo estructural e institucional, donde el acceso a la justicia y a los servicios de salud depende de la clase social, del estatus migratorio o de la racialización de las mujeres o de las personas de género diverso, ¿no? Desde Women's Link, por ejemplo, hemos acompañado casos emblemáticos que revelan estas desigualdades. Por ejemplo, el caso de Elena en Colombia, sobreviviente de violencia reproductiva en el conflicto armado colombiano, o el caso de Esperancita, una adolescente dominicana a la que se le negó el tratamiento oncológico por estar embarazada y falleció debido a eso. O Eva Luna, una mujer migrante venezolana en Colombia a quien se le negó el aborto por no tener
Venezuelan immigrant in Colombia who was denied an abortion
para nosotras
because
es
she did not
importante
have a legal
mencionar
status
que
in the
no
country.
solo se trata de ganar fallos, ¿no? Litigamos para visibilizar cómo opera la desigualdad estructural en los sistemas de justicia. Usamos también estrategias jurídicas como el amicus curiae, con argumentos que cruzan el racismo, el capacitismo, el colonialismo y el clasismo, desafiando esta supuesta neutralidad del derecho, ¿no? Y por supuesto promovemos algo que es muy importante y es el diálogo judicial sur-sur con jueces y juezas de altas cortes para fortalecer la garantía de los derechos desde el sur global, desde donde nos encontramos como una necesidad permanente, ¿no? No es la excepción el contexto en el que estamos viviendo ahora y es importante seguir hacerlo, ¿no? Asimismo, nuestro enfoque de justicia reproductiva en el litigio va más allá del derecho al aborto, porque articula el derecho mismo a decidir con el derecho a vivir con dignidad, con el derecho a gozar realmente de servicios dignos de salud, a educación sexual integral y a condiciones materiales que permitan ejercer autonomía en las mujeres, en las niñas, en las adolescentes y en las personas de género diverso, ¿no? Para nosotras es una apuesta política para avanzar los derechos frente a las cortes. Y por último, algo muy importante para responder a su pregunta es que esta lucha también se trata de una batalla por las narrativas, ¿no? El litigio no solo ocurre en los tribunales, también se disputa en los medios de comunicación, en las redes sociales y en la calle, que no nos olvidemos que en la calle también se han conseguido todos los derechos, ¿no? Las comunicaciones estratégicas y la movilización social son parte clave para el litigio estratégico, porque contar las historias con dignidad de las mujeres, de las niñas, de las adolescentes, puede ser tan o más transformador que tener un fallo favorable. Muchas gracias por el espacio y over to you, Prudence.
Thank you, Estefany, and thank you, Dr. T. Good day to everyone who is joining us today. My name is Prudence Mutiso, and I serve as Senior Legal Advisor for Africa with the Center for Reproductive Rights, which is the only global legal
Derechos
advocacy
reproductivos.
organization working to advance
Es la única organización que trabaja para avanzar.
And thank you, Dr. T, for such a great question. And I would like, just to build on to what Estefany has submitted on, and, the tension that exists between colonial era laws and progressive international, regional, and constitutional instruments in different countries in Africa. And I'm going to speak, from the perspective of the Center for Reproductive Rights and the work that we continue to do across different countries in Africa. And so when you look at Kenya, Uganda, Malawi, Nigeria, and a couple of other countries in Africa that are former British colonies, these countries continue to have penal code laws that are penal code laws that resemble or are a replica of the 1860 Offences Against the Persons Act, which was one of the laws that was enacted by the British during the colonial period. And when you look at sections 158 to 160 of the Kenyan Penal Code, which again, Kenya enacted in the year 1963, it criminalizes abortion and allows or permits abortion in a very narrow manner. Same thing for Malawi when you look at the offenses against persons in the penal code, again, narrowly allowing for abortion only when the life of the pregnant person is in danger. Same thing for Uganda. The Offences Against Persons Act through the penal code, allowing abortion only to the extent when the life of the pregnant person is in danger. And so the question that we struggle with as a Center for Reproductive Rights is all these countries have enacted, the progressive international and regional human rights instruments, whether it's Maputo Protocol, whether it's CEDAW, whether it's an international covenant on economic and social and cultural rights. But then there still exist these penal laws that do not really go in line with what you're seeing in terms of statistics on unsafe abortion. When you look at what Guttmacher Institute has stated about Kenya, Kenya is at 18% in terms of unsafe abortion, Uganda at 13%, and Malawi could be at 24% in line with the latest statistics. But still, unsafe abortion is an issue that continues to face institutional objections, if I may call it that. So when you come down to Kenya as an example, in the year 2010, Kenya passed one of the most progressive constitutions on the continent, as lauded by many human rights advocates. And the Kenyan constitutions, particularly Article 26.4 and Article 43.1, as read with Article 43.2 of the Constitution, does allow for access to safe and legal abortion and the right to health. Kenya's Article 26.4 provides that abortion is permitted when, in the opinion of a trained health professional, and this includes a clinical officer, includes a midwife, includes a doctor, and a nurse as well, that when the life or health of the pregnant person is in danger, or if there's a need for emergency treatment, or if allowed by any written law, abortion can be offered. And now when the constitution was passed, Kenya's, the same constitution, Schedule 6, Section 7 of Schedule 6, states that laws that were enacted before passing of the constitution should be modified or amended.
Se determinó que las leyes, al modificarse, tienen que estar de acuerdo con la Constitución.
The standards and guidelines on reducing maternal mortality from unsafe abortions. And these guidelines were made to guide the trained health professionals that I've mentioned as to when they can provide abortion services in line with the law, and as well guide women and girls in their diversities who require these services, where and when they can access these services. But immediately around the year 2014, as a result of what the government said were calls from religious organizations or organizations that were not quote unquote allowed to participate in this process. The government recalled these guidelines, and then that caused a quagmire for trained health professionals in the country as to when to offer these health services or when women and girls can access these health services. And so the Center for Reproductive Rights, together with other partners, moved to the High Court of Kenya in the year 2015. And a decision was issued in the year 2019 in a case known as FIDA Kenya versus the Attorney General, popularly known as the JMM decision, which is a case that affected a survivor of sexual violence because this child was 14 years old. And as a result of suffering defilement, sexual violence, she obtained an unsafe abortion. She developed complications because she could not access post-abortion care in good time. And so the center moved the court, and the High Court of Kenya, in a 5-judge bench decision in the year 2019, ruled that victims of sexual violence in Kenya have a right to access safe and legal abortion in line with Article 26.4. The High Court of Kenya also relied on international and regional human rights instruments. Kenya has a reservation to the Maputo Protocol under Article 14.2c, but the court in that particular decision stated, while Kenya has a reservation to Article 14.2c, in a way, our Article 26.4 in Kenya does mirror the Maputo Protocol, and therefore victims of sexual violence can access safe and legal abortion. But then this particular decision was appealed by groups that are opposed to safe abortion. And this particular appeal has been pending in court since the year 2019. Hopefully, we can have the matter heard as soon. But again, when you look at the pronunciation of the court from that particular case was that the blanket criminalization of abortion cannot continue in Kenya because of Article 26.4. Again, the Center for Reproductive Rights in the year 2020 moved the High Court of Kenya seeking to build on this particular decision. And in the PAK decision, which was issued in the year 2022, the High Court of Kenya noted that there's a lacuna in the law, because when you say Article 26.4 provides for access to safe and legal abortion, and yet sections 158 to 160 of the Penal Code of Kenya continue to criminalize abortion, then what is the status of women and girls in this country? Then what is the guidance that should be offered to healthcare providers in Kenya? And so the High Court ruled that the Parliament has an obligation, Parliament has a duty to enact a policy framework that will guide healthcare providers in line with Article 26.4 so that the lacuna can be addressed. Again, this particular decision is on appeal by groups that are opposed to access to safe and legal abortion. So as a Center for Reproductive Rights, this is something that we have noted, and we continue to engage in strategic litigation together with our partners in Kenya, Uganda, Malawi, Nigeria, collectively to ensure that we can address these colonial penal laws that, again, do limit women's enjoyment of the right to health and the right to benefit from scientific progress. I will stop there, Dr. T. Thank you.
Thank you very much, Prudence and Estefania. And I think from a civil society point of view, I identified a lot with what you have explained. And I think the frustration also is that litigation is expensive, right? And what Prudence have explained, it also takes a lot of time to effect the change. And coming to you, Honorable Adriana, how do we then enforce, or how do we manage our own expectation even that litigation will actually lead to these outcomes that we so desperately need? And of course, on the one hand, they may seem like shortcomings, but they're actually not, because I think for many, many people, the court becomes the only
Gracias,
place
pero no lo
para
son, porque para muchas
muchas
personas
personas,
los
las
tribunales son los
cortes
únicos
son el
lugares
único
donde
lugar
pueden
donde
ir,
pueden
a
defender sus
donde pueden
derechos
acceder
humanos.
para que se
Entonces,
proteja y
desde su
defienda
punto de
sus
vista,
derechos.
a person. What would you say to us who feel
¿cómo nos diría a
Dirías,
the
nosotros
challenge
que sentimos a veces el
nosotros
reto
que sentimos
that sometimes
de,
things take too
ese
long,
de que a
desafío
veces las
de
cosas
que a veces
toman
las cosas tardan mucho a la hora de proteger y defender?
mucho tiempo?
Well, I don't know if you had finished because I stopped listening to you,
No sé
but
si
I would like
ya
to be
terminaron porque
optimistic on one side
dejé
and be pessimistic in the other side. First of all, I would like to take this opportunity to share with you a briefly account of the most
para compartir con
recent
ustedes
cases brought
unos casos
before the
recientes.
Mexican Supreme Court
Broad
by
versus
NGOs undertaking strategic litigation. It should be underlined that the huge importance of such litigations in the success of these cases. In a couple of cases, the court found that denial of abortion services in cases of
la
pregnancies
negación
resulting
de
from rape
abortos en
was
casos
a
de
gross human
embarazo
rights violation,
resultados de
and that such
violaciones
service
es una
providers must be held accountable accordingly. Later, in other case, the court held that decision regarding abortion and access to medical services when abortion is needed due to health risks make part of the constitutional right to health. And it also ruled that health must be understood in broad terms to encompass physical, mental, and social aspects. According to the court, Mexican court, this approach also allows to consider the specific women's and people who can get pregnant, life expectations, age, poverty, and distress, among other individual challenging situations. In other case, the Mexican court ruled out the limit of the first trimester to access to abortion when the pregnancy resulted from rape. The Mexican court, found this limit to be unreasonable and endangering. From my point of view, as we have listened, this means that at this previous moment, Mexican court has increasingly engaged in protecting women and people who can get pregnant right to choose. But this story is about to get even better. Finally, as you may know, I don't know if you know it, but the Supreme Court ruled that criminalization of abortion is a violation to women and people who can get pregnant, human rights. In that case, the court held that criminalization of abortion violates the rights to life, the right to non-discrimination based on gender, race, etc., the right to privacy, the right to personal integrity, and the right to free decision-making or autonomy. All of these are constitutional rights in Mexico, not only as they are explicitly enshrined in the Mexican Constitution, but also because, and I think this is very important to underline, because human rights treaties are considered to be constitution in Mexico and therefore the supreme law of the land in Mexico. According to the ruling, coming back to the ruling, healthcare facilities and providers should provide services to women and people who can get pregnant seeking abortions. Although the decision, and this is a little shortcoming, although the decision of the court mainly applies to the state of Coahuila, I don't know if you may know, I don't know, but Mexico is a federal republic. This means that every single state has the authority to enact its own legislation. And so this ruling only affects the state of Coahuila, another state in Mexico. Although what is true is that this ruling binds every single judge in the country, and therefore no women or pregnant people of people who can get pregnant can be prosecuted or sentenced for having an abortion. In other crucial cases, the court recognized an interest of the state in protecting the potential life of the fetus. But it was also said, and I want to underline this a little bit, potential life of the fetus, an interest, not a right. And the state might have an interest on preserving this life, but does this person, this fetus is not a person, and it doesn't have the right to life. It was also said that it's not for the Mexican states, and there's a huge limitation as the local authority, state authority to enact legislations. It is not for the Mexican states to decide who and when must be considered a person deserving legal protection. Also, the court ruled that any constitutional provision, even seemingly harmless, intended to limit women and people who can get pregnant human rights was inadmissible according to the Mexican Constitution. For the court, it was apparent, and it was before for the Inter-American Court of Human Rights when deciding the Artavia Murillo case, that any purported legal protection for fetal life must go through women and people who can get pregnant. As you may notice to this point, this is the optimistic part of my intervention. So far in Mexico, the Constitutional Court has granted protection to sexual and reproductive rights and has built an important jurisprudence that might be useful to other jurisdictions for them to propose arguments based on their constitution and human rights treaties. I'm not completely, this is the pessimistic part of my intervention. I am not completely sure, to be honest, as to the court to come, the new court, to say it in some manner, will be a complete disaster regarding reproductive rights. We don't know yet. But the problem relies on the possibility that this reform yields the court to abandon its precedents with no further legal argumentation. In addition, I do think elected constitutional judges in general at the federal level in Mexico, every single judge can decide constitutional cases. It is to the highest court to review such rulings. These judges that are going to be elected could feel tempted or pressure to act according to their constituencies. And there are a lot of people in Mexico that can be very conservative. And these judges might feel tempted or pressured to act according to these constituencies because they have the opportunity to seek re-election. The reform provides for judges to stay in office for a period of 9 years, after which they can compete to get reelected. This kind of reform might open the door to conservative groups and provoke some backlash. When it comes to Mexico, and I will continue with my pessimistic approach, when it comes to Mexico, I foresee that amparo proceedings and challenges before the Supreme Court will tend to fade. Because resorting, we were talking previously about the expensive or the high cost that undergoing strategic litigations might represent for the victims. And I think in Mexico, resorting to a court with a serious diminished authority to impose its rulings will be highly unpractical, and the effort and even the cost involved might not be worth it, particularly since general effects decisions will be difficult to achieve. What I mean to say is that we will be better off designing a legal strategy that leaves behind the right-based approach to concentrate in state obligations approach instead. I said before that in the case of Mexico, it might be the time to think in a new legal strategy. Even though a huge part of strategic litigations before the court has proven effective, as one can conclude from my previous presentation, through this, that new strategic litigation should pay a lot of attention to the impact that such litigations would eventually have. Until today, strategic litigations could have easily relied on the court strong jurisprudence. This might change in the forthcoming future, at least in Mexico. As of today, in Mexico, constitutional rights are justiciable rights, and human rights treaties are part of the Mexican Constitution, and therefore are considered to be, as I said before, as the supreme law of the land. It is also clear that Mexican Supreme Court has built a strong jurisprudence regarding sexual and reproductive rights. The question remains as to whether the new court will respect this large jurisprudence. It occurs to me, for example, that an issue that might be particularly challenging could be access to reproductive health in general, including abortion. Since this kind of access entails budgetary measures, government officials might be reluctant to comply with decisions that impose on them the obligations of providing health services in general and reproductive health services in particular. Therefore, in my opinion, my very particular opinion, I might be very pessimistic at this point. I'm just very worried about what is happening, what is going on in Mexico. It might be the moment to return or to emphasize legislative and administrative advocacy. According to constitutional and human rights law, we all know it, international jurisprudence and standards, the protection of human rights is binding to these branches as well. That means that we will have to adopt a collaborative approach before the state instead of a confrontational one. My hint is that might be the time to come back to more modest litigation like family law, civil law, administrative law, labor law proceedings. This means that we can use these courts either to guarantee sexual and reproductive on the daily rights, on the daily lives of people, or try to get redress for damages which can be achieved in administrative law or civil law proceedings. I don't know, at this point, I just have to say, I don't know whether my comments will apply to the rest of the countries here. I have listened a lot of good experiences regarding litigations. Stephanie was just talking about the powerful of putting out new narratives. It has been very important in Mexico as well. I think you were talking about the importance of the social mobilization, and I think in Mexico, the social mobilization was crucial to the success of the cases I was just talking about. Well, I don't know where these comments will apply to you, but there is a quite popular saying in Mexico that goes like something like, when you see your neighbor in trouble, you will be better off taking precautions. So that will be my participation. Thank you very much again, Dr. T, and thank you very much to the rest of you. Thank you.
Thank you so much, Judge. And I think you started answering also part of our participants' questions in the Q&A around the status of Mexico, the landscape, and the judiciary. So thank you very much for that overview and just giving us your views as well. And I think it's fair, right? And that's why we have you here, so that you can give us some of those analysis in terms of how far or and how bold we can go, right? And push the envelope in terms of using the courts. And I must say, I'm thrilled that Justice Honorable Omondi Owino has joined us. She is the president of the International Association of Women Judges in the Kenya chapter. And just as I give you the floor, Honorable Justice Owino, I wanted to then just get from you your experience from Kenya in terms of the court and the judiciary, and what do you think the international standards, to what extent are they persuasive in your national context to advance sexual and reproductive health rights? We know that many member states, many governments, ratify different treaties, and we know from the right to health perspective, sexual and reproductive health rights are integral. We cannot separate those from our general health and well-being. And so, how do you and perhaps some of your colleagues use these international standards and human rights in your national context to advance sexual and reproductive health rights? Over to you, and thank you very much for joining us today.
Thank you very much. And my apologies. I had an internet connection problem almost immediately the session was to begin. And I apologize for that. But thank you for this opportunity. Let me just pick straight away from what you have requested me to respond to. Our Constitution, Article 2, 4, and 5, and 6. Actually, Article 2, 5, and 6. 1 states this: the general rules of international law shall form part of the law of Kenya. So already that means any international instrument automatically becomes part of our law. And then at Article 6 says, any treaty or convention ratified by Kenya shall form part of the law of Kenya under the Constitution. So again, any from the international covenants, the regional instruments that have been ratified by Kenya immediately become part of our law, and we apply them in our jurisprudence without waiting for any further ratification or incorporation into our justice system. In applying those instruments, we'll see reflections by the various courts, recognizing, first of all, the place of CEDAW and the right of women to maternal health and the application of the Maputo Protocol, and maybe a decision that would be of interest is one that was filed by the Federation of Women Lawyers in Kenya, and known as the FIDA, the acronym FIDA, versus the Attorney General and 2 others. And this was a situation where there had been standards and guidelines and a training curriculum, which was to train health workers on safe abortion and the use of a certain medicine for abortion. But shortly after that, a directive came out from the Director of Medical Services warning all health workers, whether in public or private, or even any other based organization, not to participate in any training on safe abortion or use of that particular drug. And it warned that anybody attending any training or using that particular medicine would face dire consequences. And the matter was taken to court. And among the issues that were raised actually was with regard to the very articles I've mentioned, their contention being that there was violation of Article 2 5 and 6 of the Constitution regarding the applicability of international law in Kenya, and violation of the African Charter, the Maputo Protocol, violation of the Children's Charter, and all the international covenants, both on economic, social, and cultural rights, as well as on civil and political rights. Other instruments that were cited included the Convention Against Torture, the Convention Against Torture and other cruel, inhuman, and degrading treatment or punishment. All these statutes were relied on, all these instruments were relied on, and among their prayers were that Kenyans and those seeking intervention in terms of their health are entitled to the highest attainable standard of health, and they have the right to non-discrimination, and they have the right to freedom and security of person, and the right to information. These were all part of the instruments that were cited before the court. The court, the Ministry of Health and the Director of Medical Services argument was that under our Constitution, at Article 26, the right to life is a right that cannot be taken away by anything else, and that therefore training personnel on abortion and carrying out abortions was an issue that should not even arise, because the Constitution already made it as such, that the right to life is absolute. Yet, when one looks at our Constitution, and specifically Article 26, sub-article 1, it provides, Article 26, sub-article 4 provides us this. I'll read it to you. One says, every person has the right to life. But sub-article 4 says, abortion is not permitted unless, in the opinion of a trained health professional, there is need for emergency treatment, or the life or health of the mother is in danger, or if permitted by any other written law. And so the court looked at the situation that was arising from this directive by the ministry and wondered, how does then Article 4 fit in with the provisions that are in our Constitution, and also with the other international and regional instruments. And happily so, in applying those instruments, the court found that actually there was violation, and that the directive that had been issued by the Director for Medical Services with regard to withdrawal of that training curriculum was a violation of constitutional rights, and that petition was allowed. I hope I've been able to respond.
Absolutely, and thank you for that, Honorable. And I want to come to Stefani, because you mentioned earlier that a lot of these rights have been won from the streets, right? And that strategic litigation is good, but often what happens is the narrative. And so, in your opinion, how do you think we can learn from each other in terms of the South to South colleagues working on this issue, using the power of organizing, using the power of media in supporting strategic litigation to ensure its effectiveness?
Muchas gracias, doctora. Me gustaría mi reflexión. Un momento. Listo. La interpretación estaba en este momento. No, sigo escuchando la interpretación en inglés y no está puesta.
No,
No.
I don't have it selected.
Ahora creo. Ahora sí.
Okay, now.
Ok, bueno, quisiera
Okay,
empezar pues la
so
respuesta con
I
una
would
primera
want to
reflexión
start
en torno a las
my
estrategias y
answer
lecciones que hemos
with
aprendido a lo largo
a
de
reflection
los años para
about
hacer más justo
strategies and things we've
estratégico y que
learned
este sea más
through
efectivo.
the years of
En un
strategic
ejemplo breve
litigation.
tenemos el litigio
First, we
objetivo
understand
mínimo, sino como una
litigation not
herramienta
as the goal
política para
itself, but
disputar
as a
poder,
political tool
para
to,
devolver el poder a las
uh,
personas y también
to
para transformar
give
estructuras
back power to
injustas.
people and
Una de
dissolve
las principales lecciones ha
unfair
sido la
structures.
necesidad de
One of
construir
the main
litigios desde las voces de las
decisions
personas
would
directamente
has
afectadas,
been to
con
build
ellas y en su
litigation
nombre
through the voices
articular
of
estos
people that are
procesos con los
directly
movimientos
affected,
sociales de más amplia dimensión.
and
Lo vimos, por
do this
ejemplo,
with
más adelante con el
social
movimiento
movements.
Causa
We saw
Justa
this
por el aborto legal
with
en
the
Colombia,
fair
que logró la
Causa Justa
despenalización del
movement,
aborto hasta
or
la semana
fair
24,
movement,
donde Women's
which
Lynch fue una de
legalized
las
the
organizaciones que
abortion
litigó
until week
ante la
24.
Corte Constitucional.
And
Y allí
they
entendimos que
had
no basta con
litigation,
presentar una prueba de
against
mando,
constitutional,
sino que era necesario
and we
construir una
understood there that
narrativa
you don't only
colectiva
have
que
to,
visibilizara
the
que la
ask doesn't have to
penalización del
be
aborto
only
no
good,
solo era
but it
injusta,
needs to be,
sino que
uh,
producía daños
we also need
concretos,
to demonstrate that
especialmente en mujeres racializadas, migrantes, adolescentes y en situación de pobreza. Lo jurídico, hay que decirlo, fue solo un frente de una estrategia más amplia que incluyó movilización social, trabajo con medios de comunicación, alianzas con profesionales de la salud y del derecho, pedagogía con tomadores de decisión y trabajo territorial con liderazgos locales. El litigio, de alguna manera, fue una excusa para abrir una conversación pública urgente, ¿no? Se creó hasta un reggaetón, suena un poco gracioso, pero esta fue una forma pedagógica y política de mostrar la necesidad de sacar el delito de aborto del Código Penal, ¿no? También creo que una de las estrategias que también hemos usado es el uso del derecho internacional y el derecho comparado, como en el caso de los anticonceptivos defectuosos en Chile. Allí cientos de mujeres quedaron embarazadas a pesar de haber seguido correctamente su método anticonceptivo en 2020. Denunciamos junto con nuestras aliadas locales de la Corporación Miles Chile frente a la Relatoría Especial del Derecho a la Salud y otros mecanismos especiales de las Naciones Unidas. Y también apoyamos acciones legales internas de responsabilidad extracontractual del Estado dentro del país. Y aquí lo importante fue mostrar cómo este no era un caso individual ni técnico, ni una falla, pues, en específico, ¿no? Sino una falla estructural del Estado que
a
vulneró
specific
los derechos
case
fundamentales de
that
la
failed,
planificación
but
familiar,
uh,
la salud y
um,
la autonomía
in general,
reproductiva de las
being able
mujeres,
to
pero
prove
sobre todo de
that
aquellas
it goes
mujeres en
against
situación de
reproductive
vulnerabilidad.
rights of
Fue
women,
clave para
especially
nosotras y para nuestras
women that
aliadas
are in
coordinar
vulnerable
herramientas de derecho
communities,
nacional e internacional para
and
lograr la
using
incidencia desde distintos
national and
frentes.
international rights, we could,
Respecto de
fight this fight in different
los
fronts.
obstáculos que creo que también van
Regarding different obstacles,
em, en esta respuesta
that
que,
I
que he
think are
preparado,
part of
ya nos
the
enfrentamos a
answer
una
I
cuestión
prepared.
y es
We've
que
also,
nos
uh,
enfrentamos a obstáculos
challenges that we
estructurales y
faced
uno de los
on
más
litigation.
profundos que
We
podemos
face
identificar es
structural
el acceso
challenges,
desigual a
and
la
one is
justicia, que es profundo, porque los sistemas de justicia en
the
nuestra
unfair
región, más allá
access
de
to
nuestra
justice,
visión, no fueron diseñados
because
para incluir a las personas, sino para excluirlas.
justice structures
Son
weren't designed
sistemas
to include
que
people.
históricamente han estado
Sometimes
al
were
servicio de
designed
quienes
to
concentran
exclude
poder
people.
y que
They
mantienen
are
o quieren
designed
mantener el
for
status
people with
quo, dejando
power
por fuera a
that
quienes no
want
tienen
to
recursos
uh,
económicos,
keep
a
status
quienes les
quo
han
and
sido
keep out
silenciados
people
sus
that don't
derechos, a
have maybe
quienes
the
enfrentan
economical
múltiples
means,
formas de discriminación.
and
No es
just
lo
different
mismo ir a una corte
discrimination forms. It's
siendo
not
una
the same
mujer
thing
blanca,
going to
urbana, con
court,
acceso a redes de
being a
apoyo,
white woman
que
from
siendo
the
una
city
mujer
with
negra,
having,
indígena,
networks,
migrante o
uh,
sobreviviente de
than
violencia.
being a black woman,
También un
indigenous,
obstáculo que
from,
enfrentamos y que también
rural
hace
areas.
parte de esta
Um,
revisión
and
estratégica de
something that
nuestro
we've
hacer litigio
seen that
es
also has to
avanzar a
do with the
global y regional de tomadores
strategic
de decisión, tomadoras
litigation.
y otros actores y actrices
People that
clave de
take
extrema
decisions
derecha,
are from the
antiderechos y
extreme right.
antidemocráticos que
They are
utilizan las
anti-rights,
instituciones, incluido
anti-democracy,
el
and
poder
use
judicial,
their institution,
para oponerse a
including the
cualquier forma de
judicial system,
justicia
to
de género,
oppose
reproductiva,
um,
racial, climática y
general
buscar también un
justice,
retroceso. Y vemos
gender
cómo
justice,
se
and
recurre
and
al
they
uso regresivo del derecho
they
para frenar avances o
use
retroceder lo
the
que se ha
justice systems
conseguido,
to
como se
stop
está intentando, por
advances,
ejemplo, en
or
Colombia y Argentina, ¿no? Como
even
una
go
decisión tan
steps
importante como
backward
la de
of
las
things that have
24
been
semanas,
achieved,
todavía hay
that
presencia de
decision of,
que quieren
24 weeks,
desintegrar esa
there
decisión
are
y no
still
son
groups that
posibles de
want to
andar, ¿vale?
revert that
Todo esto, pues
decision, and we need to
definitivamente, la
defend
idea
it,
de
right?
la neutralidad del derecho es un mito y que los
Shows that
tribunales,
law
lejos de ser
being
espacios puramente
neutral is a
técnicos, son
myth,
espacios
and
profundamente políticos
they're just
donde se disputa el
very
sentido mismo de los
political
derechos y de
spaces,
la democracia. Y
where
también desde ahí resistimos, ¿no?
rights for democracy
Y
and
como sociedad civil también me gustaría nombrar el rol fundamental de la sociedad civil y de los movimientos feministas y la solidaridad
So
entre ellos,
also
¿no? La
the
sociedad civil
social
organizada
solidarity
ha
and
sido
feminist movements.
históricamente la
Uh,
fuerza que empuja
Civil
los
society has
vínculos del derecho, que
historically
sostiene las
been
luchas
the one
cuando los
to push the
sistemas
struggle, the one to
institucionales
sustain
fallan
struggle
y que
when
acompaña a las
institutional
mujeres y
systems fail
personas
us.
LGTBIQA+,
And they're the ones
cuando el
who
Estado no lo hace.
accompany
En
LGBTQ
causa justa,
persons
por
when the
ejemplo, fue
state
la
does not do
articulación de
so.
más de 100 organizaciones de
Causa Justa
activistas,
was the
docentes,
articulation of more than
médicos,
100
juristas,
organizations made up
artistas
of
y colectivos, lo que
medical
dio
personnel,
legitimidad social a la demanda. Y en el
lawyers,
caso de los
activists,
colectivos
artists.
defectuosos en Chile, ha sido,
And
por
in the
supuesto, la
case
apertura de las
about
organizaciones feministas en Chile
birth
la que ha
control,
sostenido el
effective birth
debate
control in
público,
Chile,
a pesar del
the feminist
silencio
organizations in
institucional.
Chile have sustained
Además, y como ya decía
that
antes en la primera parte de la
that
intervención,
issue.
no podemos dejar de
And as
hablar
I
de
mentioned in the
otras
first part
narrativas que también
of
hacen
what I
parte de
was
las
saying,
estrategias de
we
litigio.
can't stop
El
speaking
litigio también
about
ocurre en el
the
espacio
narratives that were
ciudadano,
also
en
part
los
of
medios de
the litigation,
comunicación, en
that
las redes
litigation which
sociales,
also
en la calle,
occurs
con la
in the
movilización y
media,
con el
on
abrazo
social
fraterno de las
media,
feministas
in the
cuando
streets,
salimos a protestar.
with, for
Las
example,
comunicaciones
feminists
estratégicas y
going
de
out and
movilización
protesting.
social, desde el
So,
entendimiento
social
que tenemos en
mobilization
Women's
and
Link,
these
son
strategic
herramientas
movements
clave para disputar
from the
intereses
understanding of
comunes,
Women's Link,
para
they're
amplificar las voces
strategic
históricamente
tools
silenciadas y también
to
generar, esto es
elevate
algo muy
voices
importante para
historically
nosotras,
excluded and
generar nuevas
silenced. And
comprensiones
also
raciales
something that's equally
concretas de
important to
derechos,
generate new
justamente en
social
el contexto
understandings
como que
of
estamos viviendo
rights,
ahora de una alzada
exactly in the
de la
context
extrema
of what we're
derecha y el
living in right now,
colonialismo
the far
blanco.
right and
En
white
definitiva, para
colonialism,
nosotras, defender los
which seem to
derechos
be
sexuales y
advancing.
reproductivos desde el litigio
Defending
estratégico
sexual and reproductive rights
implica
from
varias cosas, pero
the
implica,
standpoint of
por supuesto,
strategic
disputar
litigation
la ley,
implies many
las
things. But of
narrativas y las
course,
estructuras de
disputing the
poder.
law, the
Esa es la
narratives,
apuesta
and
por
the
construir
powers,
justicias
structural
en
powers.
plural,
We want to
no solo
create
en los
justices,
tribunales,
plural,
sino también en
not
la vida
only in the
cotidiana de quienes
courts, but in everyday
históricamente son
life
excluidas.
of those who've
Muchas
been
gracias,
historically
doctora
excluded.
Lalen, y
Thank
over
you
to you,
so much,
Prudence.
Dr. Darling. And Prudence, I'll hand it over to you.
Yeah, and Prudence, perhaps before you come in, maybe speak also a little bit about the partnerships that you have established in terms of working with communities, taking from what Estefani has just said about, feminist organizations and the fact that, the movements are sustained by the politics of giving power, but also taking power. And so, for you in your region, but also in the organization that you work through, how has that looked like in the face of litigation, where you are partnering with communities and feminists and women on the ground to ensure that their rights are protected? Over to you, Prudence. And thanks, Estefani.
Yeah, thanks, Dr. T, and thank you, Estefani. And so to build on to what Estefani has once again submitted on, I would like to speak on a couple of lesson strategies and, of course, barriers and bringing in the issue of partnerships, as you have requested, Dr. T. And for this particular issue, I want to center the case of Josephine Majani, who was again a victim of maternal health violation. And so in the year 2013, Josephine was made to give birth on a concrete floor in the western part of Kenya. This case was captured by the media and shared. And the Center for Reproductive Rights, through one of its partners, the Kenya Medical Education Trust,
Center for Reproductive Rights, a través de uno de sus socios, el Consumer Medical Education Trust, basado en Kenia Occidental, se enteró de este caso. Entonces, en el año 2014, utilizando el caso de Josephine como sobreviviente para contar esta historia a través del punto de vista de la sobreviviente, para traer a la luz estos problemas. En el 2014, el Tribunal de Kenia dijo que las mujeres y niñas adolescentes en el campo tienen derecho de acceder a una salud materna justa y segura. Entonces, Josephine llegó a ser una campeona de esta salud materna. El centro de Ngoma, donde tuvo su parto Josephine, dijo que no hubo suficiente evidencia que se le dio al tribunal y este gobierno ya había admitido a los problemas estructurales e insuficientes a la hora de proporcionar este servicio materno. Entonces, en el año 2024, en febrero, los tribunales confirmaron o mantuvieron su decisión. Entonces, nuevamente dijeron que era necesario la salud y la dignidad de la salud materna. Entonces, a menudo uno encuentra que en los litigios estratégicos tienen organizaciones civiles de la sociedad que no van a trabajar con las comunidades, no van a buscar a personas que puedan compartir sus experiencias vividas acerca de este tipo de violaciones. Entonces, una pregunta que hizo la Corte de Apelaciones es que lo que están buscando, los daños y perjuicios reclamados no pueden utilizarse para abordar alguno de esos temas que ustedes están trayendo a la luz, como las deficiencias estructurales. Entonces le dijimos a este tribunal que lo que fuese esta indemnización se utilizaría para apoyar a Josephine. Hemos perdido el audio.
Am I the only one who can't hear Prudence?
¿Soy la única que no puede escuchar a Prudence?
No, seems to have lost her sound.
No, parece que ha perdido su sonido.
Prudence, we can see you, but
Prudence, te podemos ver, pero no te
so
podemos
unmute yourself
escuchar.
again and,
Entonces, si quieres, enciende tu micrófono de nuevo y puedes seguir adelante.
Can you hear me now?
¿Ahora me
yes, we
escuchan?
hear you now.
Sí, te escuchamos.
All right, I
Perfecto.
think I'll just be close to
Ok.
the video
Creo que me
network
voy a
because, I
acercar el
believe I
video al
have
audio
an
porque creo
unstable
que
internet connection.
tengo una...
So going back to the case of Tanzania, the Center for Reproductive Rights works with the Legal Human Rights Center, which is a national organization based in Tanzania and providing legal aid services to individuals in Tanzania. And Tanzania had the practice of forced pregnancy testing for pregnant learners and expelling adolescent girls from school because of pregnancy and not allowing them back into schools. And one of the things that Tanzania was advocating for was if these girls were to come back into the education system, then they would need to do the informal education system, whether it's dressmaking, tailoring, or catering. And so together with this particular partner, the Center for Reproductive Rights moved the African Committee of Experts on the Rights and Welfare of the Child. And in the year 2022, in September, the Legal Human Rights Center and the Center for Reproductive Rights received a very progressive decision from the committee on behalf of Tanzanian girls. And this particular decision advocated for the ending of the mandatory and forced pregnancy testing and readmission of all pregnant learners, and of course called upon Tanzania to provide comprehensive sexuality education and youth-friendly SRHR services. And so again, we continue to see the power of partnerships in the work that we do. Speaking on strategies, once more, I'd like to highlight the key role that amicus briefs play in shaping the narratives or the jurisprudence that comes from court. And so we have seen interventions by international human rights organizations, by national level organizations, by the special mandates, including the UN Special Rapporteur on the right to health, Dr. T, in some of the cases. And these particular amicus briefs bring in a wealth of experience, global perspectives, comparative aspects that enable, a shaping of a progressive decision from the court. We've seen these interventions in some of the cases that the Center for Reproductive Rights has filed. For example, in Uganda, the Center for Reproductive Rights is working with a local partner, the Initiative for Social Economic Rights, on a case on maternal health. And Dr. T, through your special mandate, you've also intervened in that particular case with an application as an amicus to the court. And these amicus briefs are very critical because what the example that I'm gonna share of Malawi, the Center for Reproductive Rights intervened again with a partner who is based in Malawi, the Nyale Institute. And as a result of intervention in a case that looked at the criminalization of adolescents who are engaging in coercive, non-coercive, non-exploitative consensual sexual relations, we were able to get a decision through consent, and the decision allowed, or rather made, the Director of Public Prosecutions to move ahead and ask Parliament to amend the Penal Code to allow for close-in-age exemptions for adolescents who are engaging in consensual, non-exploitative, and non-coercive sexual relations. And so, again, it's through the power of law, and it's through the partnership, whether with special mandates, grassroots organizations, or national level organizations. And I'll stop there for now, Dr. Tim.
Thank you so much for that wealth of sharing of the various examples. And I think the different country experiences and examples are very rich because often we think that the problems that we have in our own countries are insurmountable, or we may think that they're so different that there isn't much to learn from. And I think what we are realizing today is that indeed the South to South learnings and sharing of strategies is actually an important step to do in how we protect and promote human rights. And because Honorable Omondi, you joined us, and I wanna give this question to you from the Q&A as it was directed to you in terms of advice in litigation in countries where they have a dualist system, that is where the international covenants do not form part of their law unless domesticated. And that comes from Consolanata, who's asking that question to you. And I think it's just fair to also give you more time to hear from you in this session. Over to you, Justice.
Thank you very much. Before the year 2010, Kenya was actually in the same position as the country that the question comes from. For every treaty, convention, any other international instrument, we would first have to ratify and then domesticate. And that was a very winding way of doing it. But recognizing that without ratification and without domestication, you would not be able to apply it effectively in our laws. I think one of the things that we embraced was, one, to use strategic partnerships to lobby for legislations so that you'd get your parliament, the legislature, passing and enacting laws that would be in line with the international law and with the relevant treaties and conventions, so that it would form part of your law and not wait for the international for the domestication of that. That is one strategy. Of course, the other one would just be strategic litigation, so that you get an organization and like Prudence has mentioned, someone who's lived through that reality to move to court to seek for certain change in legislations. When you work with politicians as a court, you are a bit careful on how to approach them. So it is better when you encourage those whose code of ethics do not restrict them to adopt strategic litigation. I think strategic litigation works very well if you use probably those who would be referred to as non-state actors to try and be able to get a change in legislations. I think those 2 points would be my point of intervention on getting strategic litigation, and of course trying to get the legislatures themselves to be able to pass laws that would be in line with the international instruments and regional instruments as well.
Thank you very much, Justice Omondi. And I think maybe Justice Adriana, when it comes to this idea of leaving no one behind, and as someone who works within the UN, it's something that frustrates me very much because we are already leaving people behind. That is a fact. And so for me, there's an urgency that's required in how we then understand, for example, issues around disability rights and the rights of those young women and girls who have disabilities as well. And how have you, perhaps in some of your work, in some of the interventions that you've made in the court, you've made sure that you are intentional in leaving no one behind? And someone did ask specifically around disability and sexual and reproductive health services.
Well, in every case that I have just referred to, we have we consider disability rights. And for example, today I'm a labor law judge, and I just made a law. We have, we have adopt rulings regarding disability rights in the workplace. And I think well, you have to think about sexual and reproductive health. That is the purpose of this webinar. But I think that is very important to, encase the vision. I don't know how to explain that, but it is important. And particularly in the case of Mexico, to look to other kind of litigation, because Mexican NGOs have been very concentrated in constitutional litigation. And although we can use constitutional law, constitutional rights, human rights treaty, I think it's the time to look to other kind of litigation. Family law, labor law. For example, when it comes to disability rights, family law is very critical. Recently, the Mexican court has deemed this interdiction. I don't know if you know the figure, the legal figure, that it provides for people having disabilities or facing disabilities, people for disabilities, to be represent every single time at every single legal proceeding but someone else. And this kind of legal approach has been deemed as unconstitutional by the court. So, and this litigation was reached the court of coming from family law. So I don't know, I think that I have been just like very confusing, but for me, this is the moment to think in other kind of litigation, not only constitutional litigations. As Stephanie was saying before, it's very important to resort to this possibility to make responsible the states for leaving people behind, for not complying with human rights treaties, etc. And for that, you don't need forcibly constitutional litigation. And finally, the court, the Mexican court in particular, when it has decided sexual and reproductive rights cases, it has always addressed structural discrimination. Has always take into account this structural discrimination. The problem remains as whether the government run facilities, the government official, the healthcare providers are made aware of these cases and are made aware of these rights. I think we have a very important challenge there. I don't know if I answered your questions, so very sorry. The
No,
problem is the
absolutely.
English is not my first language.
And also, we don't owe each other perfect English, Judge. So that's another thing. So that's okay. And you have answered us very enriching perspectives. And thank you very much. And I just want to do a time review for all of us that we have about 5 minutes left. And I would like to give Estefany Prudence and, of course, Justice Omondi time also to just give us your reflections in your final remarks in terms of perhaps looking forward. What are some of the areas most promising for you in terms of the various stakeholders that need to be involved? How else do we speak to young people, policymakers, and meaningfully engage, right, in this agenda to protect and to advance in terms of human rights? And so I will start with Prudence and then goes to Estefany and then give Justice Omondi the final word before I do the conclusion. Over to you, Prudence, and then Estefany.
Thank you, Dr. T. Just confirm that you can hear me.
Yes, we can.
Great. So, my reflection for these, I think as an African and, looking at the movements in Africa, I do feel challenged by the Casa Oster movement in Latin America. And that's really a great lesson for African civil society organizations, working to advance SRHR within Africa. We need to have solidarity among civil society organizations. One of the things that we are witnessing in Kenya at the moment is strategic lawsuits against public participation that are being brought by opposition groups or people who are opposed to SRHR. And we have seen civil society organizations who are pro-rights come together and co-create legal strategies to counter these defamation suits that are being brought to stifle the advocacy for SRHR. The other thing that we really need to do is continue to engage with treaty monitoring bodies to ensure that we have progressive norms and standards at the international and regional level through, the submission of shadow reports or through engagement to develop general comments that are useful, within the domestic system. And the other issue, as I close, it's important, to continue to sensitize policymakers, to sensitize judiciaries and work hand in hand with judiciaries, because a lot of the time, judicial officers and policymakers are not aware of some of the progressive decisions that have been issued to advance sexual and reproductive health rights. Thank you, Dr. T, and I hand over to Estefany.
Muchas gracias, Prudence, y muchas gracias, doctora Tlaleng. Pues de cara al futuro, creo que una de las áreas más prometedoras para la colaboración interregional, pues entre América Latina, el Caribe y África y más allá, creo que es aprender mutuamente de nuestros movimientos feministas, ¿no? Como la ola verde en América Latina y el Caribe, y pues desde África también lo que podemos aprender de este lado del mar, ¿no? Para nosotras estas luchas por la justicia reproductiva no solo han ampliado los derechos, sino pues también han defendido nuestras democracias contra los retrocesos de los derechos. Y para nosotras es fundamental fortalecer estas alianzas feministas transregionales como una apuesta política del cambio y del mantenimiento de los cambios sociales obtenidos, ¿no?
with
Otra prioridad
social
urgente es
changes,
invertir en
changes that have
liderazgo
been
en las instituciones del sur global. Necesitamos financiación, pero también necesitamos apoyo político, acceso al poder y protección, especialmente ahora que nos enfrentamos a riesgos cada vez mayores como el acoso legal, los ciberataques y la criminalización. La resiliencia es colectiva y también debemos construirla juntas. Creo que otro punto importante es que la tecnología también es una frontera crítica en este contexto. En Women's Link estamos trabajando para utilizar las herramientas digitales para decolonizar la ley, pero sabemos que estas herramientas tienen profundos sesgos y por eso consideramos también que la tecnología y el espacio digital y los derechos humanos son otro espacio para la innovación conjunta en esta intersección de movimientos y de abrazos entre los movimientos. Para hacer realidad esta agenda, creo que es importante también mencionar cómo la filantropía y los financiadores y financiadoras deben invertir en estrategias flexibles y a largo plazo, y los responsables políticos deben proteger el espacio cívico también. También los jóvenes deben ser considerados y consideradas jóvenes líderes clave y no solo como defensores o defensoras, sino como lideresas y líderes clave en el cambio y en el mantenimiento del cambio social. Juntas, juntos y juntes podemos construir un movimiento transregional poderoso por la justicia reproductiva, pero también por el Estado de Derecho y por las democracias en el mundo. Muchas gracias por el espacio, doctor T, and over to you.
Thank you very much. And Justice Honorable Helen Omondi, you have the last word for us in this webinar before I do the closing. Over to you.
Thank you very much. I think there is a group that falls in the very vulnerable category, just apart from women and children and persons living with disabilities. The youth and the adolescents are one group that really need to be included and should not be left behind. How will we do that? My question is, how will they know if we do not tell them? I think given the current global economic downturn, we need to use what we have. We have with us time and we have with us knowledge. And we can do comprehensive education awareness campaigns within our communities. At least the International Association of Women Judges does that. We go to schools. Our members in the different regions go to schools to sensitize young men and young women on their sexual reproductive health rights. We go to churches to sensitize still on the same issues, because we realize that these are places where you can easily get a collection of people without much effort. So that involving communities in SRHR, I think, is critical. And public education initiatives so as to address misconceptions, to promote positive attitudes, provide accurate information on sexual reproductive health rights is key. We, as persons within the legal profession, I think we must also acknowledge that to some extent we have our limitations, because this is an area that is a mix of human rights, but it also has with it the scientific part, and that there may be some technical areas that will require us to collaborate with those that have the know-how, so that we can be effective in having an inclusive approach for everyone. Otherwise, we'll end up in a situation where you have a judicialized approach to even policy and policy making, and I don't think that is what we want. We want a situation where everyone within our community, within our society, feels that they form a very important cog in the wheel of justice and in the wheel of the entire community. Thank you so very much. I hope I've not overshot the time.
Not at all, Judge. I think it's always a good time to have a conversation with amazing, amazing women on this panel, sharing and learning in terms of a South to South collaboration. From me personally, I just want to say thank you very much to our panelists for a wealth of information. And I can't agree with you more, Judge. We have time and we have knowledge, and we must involve communities. And I want to acknowledge all our participants who have joined us for this discussion, all of the people joining from everywhere in the world. We know that the anti-rights movement is pushing not just to undo progress, but to impose on all of us an alternative of a world that we will just simply not have. And so this work, these conversations are really important. They're critical in countering those very narratives. It is important. This work is urgent. And so using the national, regional, as well as in the international courts to catalyze change to advance on sexual and reproductive health rights becomes mandatory. And so we must, I think, as well, develop effective follow-up mechanisms to ensure that the court's decisions are also implemented. We must start with what it takes for the most of us who are vulnerable to thrive. And I want to invite all of you to join us still for this sexual and reproductive health rights webinar series, which I will continue to host, happening throughout until the month of June, where we will be exploring different aspects of strategic litigation, sexual and reproductive health rights in the different regions of the world. More importantly, as we build, as we push back, but as we move forward and past against all of the anti-human rights, but as we know that human rights are indivisible, human rights are interconnected, and human rights are non-negotiable. And so thank you to all of you, the panelists, as well as all of the participants. And my name is Dr. Tlaleng Mofokeng, and I'm the UN Special Rapporteur on the right of everyone to the highest sustainable standard of physical and mental health. Thank you so, so much.